dedicated about an hour, I would say. I always make a disclaimer at the beginning of this topic and say, 1 hour is never enough. I can talk for about 3 to 4 hours on this, and I've run seminars for about 3 to 4 hours on this. And as dry of a topic it may sound, it's actually very interesting. And there are a lot of, general issues and themes that we tend to unpack within the context of this topic. So I'll begin, inshallah. Firstly, I was thinking about sharing a screen. At this point, I won't. I just want to keep it as, I guess, generic, organic, I would say, as I possibly can. Make it, have a discussion for about 40 minutes or so, then open it up to Q&A potentially. So if anyone's got any pressing questions and so forth, I'd like to give everyone, or, for those who want the chance or the opportunity to ask any questions. So I always start by reflecting on some stories and case studies, I guess, that I've actually been involved in or come across throughout my, time as a solicitor, and particularly within my scope of work around wills and inheritance. And for those who haven't, attended any of our seminars before, just for, I guess, some context and background, the reason why I have a deep interest in this particular area of law is I did a thesis when I was doing my master's in Islamic studies. I actually did a thesis on a comparative between the Australian inheritance system and the Islamic inheritance system. And I tried to, I guess, raise some key issues that are often, the point of contention in wide and mainstream, I guess, media and so forth, in that, Islam is oppressive even when it comes to inheritance and so forth. And subhanAllah, the hypothesis that I actually came up with after going through some case studies and comparing, case studies around the Australian legal system in succession law and the Islamic, was that Islam is actually the most just system, and the justice of Allah subhanahu wa ta'ala can never ever be surpassed, in that there is absolutely nobody that is left when it comes to inheritance. And Islam is one of those religions, subhanAllah, the only religion that in fact is not emotive. It's not based on emotion. So we don't make decisions based on emotions. We make decisions based on divine wisdom, and at the same time based on what's in the best interests of those who are entrusted to us. So that's just some background as to why it is that I have some, I guess, a deep connection to this particular topic. So the stories that I normally like to reflect on as a start are three. One of them is about a sister that actually embraced Islam in 2015. So she was a revert sister. She fell severely ill, subhanAllah, months after she became Muslim, and she passed away months later. She did not have a will in place at the time. Her family members at the time were also not aware that she had embraced Islam. So again, because it was still very early phase in terms of her practicing and embracing Islam, she had not yet had the opportunity and was a bit reluctant, I guess, to let her parents and family members know. What ended up happening in that particular scenario was at the time of her burial, unfortunately, her family members, being her parents, being her next of kin, had full autonomy as to how it is that her body was to be buried. So they actually decided that she be cremated. And, community members stepped in from the Muslim community and tried to negotiate, I would say, with the family as to whether they could at least offer her a Muslim burial, and they refused. And from a legal standpoint, they have every right to make that final call. And subhanAllah, she was cremated. The second story was about a Muslim brother who passed away suddenly. So he was actually a resident and citizen of this particular country of Australia. However, he had family members in a country abroad. He was only in his mid-30s. He passed away suddenly. There was no will in place. His family members abroad actually requested that his body be transported overseas so that he could be buried in his homeland. Now, when that happens, you can't just transport a body. It has to go through the embalming process. And we'll touch on embalming. But what had happened was, obviously he had to be embalmed, and he was later transported to his homeland. again, no will in place, no opportunity to express potentially to his family members even that he may have not wanted to be embalmed. So that's the second story. The third story is about a stepmother. She was elderly in age. Her husband passed away and he left behind adult children and so forth, and she was not accounted for in the will. Now, obviously, she had a claim under the legal system, a family provisions claim, which she pursued. But what had happened was, you know, Islamically speaking, she was not accounted for. And, you know, it triggered a legal issue for her, and it was pursued in the courts. So the reason why I like to start off with these stories is that even though, and I'll make this very clear, even though absolutely every legal document you could possibly think of that is drafted in your lifetime is open to challenge, including your will, it is always better to have a will than not have a will. Because people always ask me, well, if it's going to be challenged, what's the point? So the likelihood of it being challenged is usually rare. So the majority of wills are usually not challenged. That's the first thing. The second thing is in the event it is challenged on a family provisions claim or invalidity claim or whatever it is, at least, you know, the judge has something to fall back on, and that's the will and the wishes or potential wishes. So it's not left to, it's not left for mere speculation. It's something that at least is there for the, you know, legal representatives and the parties to the proceedings can actually go back to. So when we ask, do I really need a will, right? As Muslims, do I need a will? That's the first question that's usually asked. First and foremost, it's a command from Allah subhanahu wa ta'ala. And we know, you know, time and time again, particularly in Surah Al-Baqarah in verse 180, Allah subhanahu wa ta'ala says, if one of you facing death can leave a legacy, he should bequeath it to his parents and relatives according to the law. This is a duty to, or this is a duty of the pious. So first and foremost, it is a command by Allah subhanahu wa ta'ala. Right. The second is the prophetic advice and recommendation as to the importance of having a will in place, in that the Prophet, peace be upon him, has said, it is the duty of a Muslim who has anything to bequest to not let 2 nights pass without writing a will about it. So these are two critical and essential, I guess, commands, not only by Allah subhanahu wa ta'ala, also by the Prophet, peace be upon him, as to the importance for to have a will in place. Now, the added layer to this is that we don't live in a Muslim country, right? So if you lived in a Muslim country, there is a likelihood, a high chance that, you know, the Sharia will be applied and that your estate will be divided in accordance to Islamic law. We don't live in a Muslim country. So you need to stipulate these wishes in writing. And we'll talk about, I guess, the requirements of a valid will here in Australia, at least. Because what I have at times is that I've got clients who usually ask, well, I've stipulated my wishes to my child or my daughter or my son, is that enough? And I say no, there are key legal requirements in order for a will to be valid here. So the first thing is that it must be in writing. There's no such thing as oral or verbal wills. A will must actually be in writing. The second thing is that it must be signed by the testator, the person who is writing the will. It must be dated. There must be 2 witnesses who are of sound mind and are 18 years and over. And then all parties need to sign all pages. So just throwing it out there, why do you think, for example, the date is critical? Why would the date be critical in this particular scenario? I'll ask the host, Yeliz, since you may be the only one who could, you know, I want to have a conversation rather than just.
I guess maybe I'm thinking you can update a will.
I couldn't hear you there.
Sorry, I'm guessing that maybe you can update a will, so that you could probably have, you know, if you were married, you probably had a divorce, or, you know, there was, things that changed. So you need a date to say that so I don't know, maybe depends also on how long a will is valid for.
Yeah.
And debts as well, you know, debts need to be updated too.
Yeah, absolutely. So the first and foremost and most important reason as to why a will needs to be dated is that in the event it is challenged or questioned, and particularly the mental capacity of the deceased is ever going to be questioned, at least we have a date to go by. So for example, let's say you had an elderly person who had just done a will. They passed away shortly after, and then one of the beneficiaries or family members or eligible persons challenged the will on the basis of that person not having mental capacity at the time. For example, they lacked mental capacity. We would need to investigate and provide evidence for that entire period before they signed the will as to whether they actually had mental capacity. So that's the first thing. The second thing is in the event that you obviously have prepared several wills over time. So we always say, if you update your will, destroy the previous one. Although the most current and recent will always supersede or automatically void the older will. We just don't want confusion to happen. And we've seen that happen sometimes. We've had one beneficiary flash one version of a will and another beneficiary flash another version. And the one that we go by would be the most recent version. So that's why date's really critical. And obviously, of course, any change in circumstances will require you to update a will. Now, a lot of people have asked me, oh, I did my will 20 years ago. When does it expire? A will never expires. As long as it ticks all the procedural requirements, as in it's in writing, it's signed, it's dated, witnessed, and all parties have signed, I guess, all pages, it never expires. The only thing that will void it is change in circumstances, such as marriage potentially or divorce. Updating a will, and obviously the older one will be voided, but there is no expiry for will. But the advice always is generally, just review your will at least every 5 to 10 years. That's the advice, so that at least if there is a change in circumstances, we're at least able to accommodate for it. Now, every Muslim after death has a duty, right? So there are duties of a Muslim after death. The first and foremost, obviously, once a deceased person has passed away, it is an obligation on the, surviving, community to ensure that certain obligations are fulfilled for the deceased. The first one is obviously in that, the deceased must be washed, shrouded, janazah prayed, and then buried, right? They're a given. There are then secondary duties which must be fulfilled, and they're generally the duties of the executor, the wasi, who will, fulfill those obligations in the presence of a will. So first and foremost, the first thing that needs to be done is funeral and burial expenses need to be accounted for from the deceased estate. The next thing that's accounted for are debts. So absolutely all debts need to be paid before anything is actually distributed. That's both legally and Islamically speaking. The third, the executor, he or she must execute the will, because a lot of people ask me, what is an executor? Your executor is going to be the most trusted person you would choose to fulfill your wishes and ensure that the wishes that you've stipulated in that will are fulfilled, right? So we always say, make sure you choose someone who you trust, who is at least, very similar in your values and principles and obviously beliefs. And our recommendation generally is that for particularly husband and wife scenarios, that you be each other's executor at the first, option, and that you have secondary executors. So in the event that you both pass at the same time, there are secondary or backup executors. So the executor will be responsible to execute the will and then subsequently distribute your estate. So your executor will play the most important role that you would ever imagine once you've passed, right? You are literally entrusting them with fulfilling and undertaking all your instructions and wishes in a time where you are in no control whatsoever. So it's a very important and undoubtedly a very heavy responsibility. Now, I just wanted to quickly touch on, you know what, let me just, I know I can imagine that there are already questions. Let me just see if I can go through it. Sorry about that. No. Okay, after my husband, if there is no family in Australia, Who can the second executor be? That's an interesting and important question. I always get asked that by clients. So if for example, if my husband is the only executor and I don't have a backup, who do I choose? Look, if you have absolutely nobody, you can appoint the public trustee as a potential executor. We don't usually recommend that because, you know, they're just, it's systematic and it's a process, so it's not straightforward. If you have any trusted friends, if you have any trusted, you know, anyone that you would know possibly who is at least able to fulfill that task here in Australia, we always recommend it. And reason being is that logistically, it'll just make things a lot easier. You can definitely appoint a family member overseas, but that will all be subject to them actually arriving to Australia. So it's always good to at least have that middle person who is able to facilitate the process for you in the absence of an overseas family member being able to attend. Now, I've actually raised this issue with the Australian National Imams Council because we've noticed there are a lot of new arrivals who come to Australia and they have absolutely no family or friends whatsoever. And they are usually stuck in these scenarios. So in the event that they do pass, they do need an executor. They do need potentially a temporary guardian for their children. What we are proposing, and honest, it's something that's in the pipeline, but it's not concrete as yet, is that we think about at least having some endorsed and you know, respected and trusted members in the community who can be recommended potentially in scenarios like this to be able to fulfill this particular task. It's a very, as I said, heavy and difficult task. It's not something that's very easy. It's not something that's easy, but it's definitely something that we are recommending. I also advise that if you've got children over the age of 18, that you consider appointing them as backup executors. And if you've got more than a child, so say, for example, you've got 5 children, I always advise that you appoint, for example, 2 of those children. That way they can at least liaise and consult with one another on important matters. And in the event that, you know, there is a bit of a complication and so forth, at least there are 2 people to make decisions in those particular scenarios. Just very quickly, like when we talk about the components of a will, because many say, what do you actually cover in the will? So generally speaking, and particularly an Islamic will, we normally have a testimony of faith. So just to clearly highlight that, you know, you are a Muslim, we're talking an Islamic will here. If you are a Muslim and you'd like to stipulate that you are, you know, you believe in Islam and you follow the Muslim faith, it's always good to stipulate, and we like to include that. We then specify the executor's details and appoint an executor for the estate. We then consider all the funeral and burial costs and expenses that need to be accounted for, as well as account for debts that need to be paid out, not just debts owed to people, but even debts owed to Allah. So in terms of unpaid, you know, kafara or expiation, or even unpaid dowry for some of the brothers, whatever it is, unpaid days for fast or unpaid days for any other issue that is owing to Allah subhanahu wa ta'ala, we also include that in the will. Now, I know it's very difficult to specify, but at least it's stipulated there, and we always say you should raise these issues with your beneficiaries or your executor so that they're at least aware, to ensure that they do pay off your debts that are owed to Allah. After that, we then begin the distribution of the shares to the primary beneficiaries. So your parents, your wife or husband, your children, and it just continues from there on. Now, there's also a secondary charitable contribution that's optional, right? That you have the autonomy and authority and power to decide what you'd like to do with it, and that is the wasiyah, the 1/3 share. So Islamically speaking, the only thing that you can actually deal with without any restriction is 1/3 of your estate. That's the wasiyah, right? Now, Islamically speaking, you cannot give that to any of your primary beneficiaries. So I've had clients that ask, can I give my 1/3 to my daughter? You cannot give it to a primary beneficiary. So the 1/3 share, if you want to exercise it, is usually that particular share that's given to a charitable contribution, such as a sadaqah jariyah, you know, to a mosque, to an organization, to a project that will, you know, benefit you when you are no longer here. Say, for example, you have a needy friend or a particular person that you know is in need financially, that you would be able to assist. It is also an opportunity for you to assist. And I always advise clients, particularly Muslim, obviously, clients, this is the time. This is the time that you can potentially purchase your ticket to Jannah. Don't wait for your beneficiaries to pay a sadaqah on your behalf. This is your chance to, I guess, pay your way into Jannah, inshallah. So always remember that 1/3 share. Don't overlook it. You don't have to exercise the full 1/3. So you can be very specific and say, I would like to give $5,000, or I'd like to give, you know, a specific sum, or, you know, half of the third, whatever it is, but your cap is a maximum of 1/3. You should not exceed that, because it goes back to the hadith of the Prophet, peace be upon him, in that you should always ensure that you have looked after your family. You don't leave them in a state of need and give away your money in charity and then have them need charity themselves. So it goes by that. And the other thing that we account for also in the will is guardianship. So if you do have children under the age of 18 and you and your partner pass away at the same time, this is an opportunity for you to actually think about who you'd like to be granted the responsibility and the entrustment of having to raise your children, right? Obviously, this is open to challenge, but I always say it's always better to stipulate your wishes by way of, you know, appointing a guardian than not. That way, should it be challenged in the courts and so forth, then at least, you know, your wishes are there and it's quite clear. Obviously, if the parents, the biological parents of the children, are divorced or separated, that's also open to question and to challenge. So you'll need specific advice on that. Let me just check if there are any questions in relation to what I've just talked about. What if someone dies without writing will about children? Okay, so this is only in the event that you and both biological parents pass away. Look, your children are not going to be thrown into, you know, the institution, as they say. If there are immediate family members that are willing to look after your children, obviously they will get the first priority, but they may not be to your liking. That's the point. So when you have a will in place and you've appointed guardians, you would have at least had the opportunity between you and your partner to sit and think about and nut out the specific details about who you'd like your children to be raised with, how they'd like to, how you'd like them to be raised, and what specific details you would like in between. So, for example, how to spend money on them, you know, what schooling and education they are to pursue, the values and the ethics that you'd like them to be given as well. So it's just an opportunity to address those issues in the event that both parents actually pass at the same time. Just moving on, I wanted to quickly touch on organ donation, because I know it's always an issue that's you know, a bit contentious. So the legal standpoint is that there are two main ways generally to indicate your intention to donate your organs once you pass. So either through your driver's license or by registering as an organ donor on the Australian Organ Donation Register. Even though, and even if you express your wishes and intention to have your organs donated, the next of kin will still be asked, firstly, two questions. Firstly, whether you had changed your mind since you recorded your intention to donate your organs. So for example, say on my license, I am an organ donor and I made that decision, but suddenly I've gone through an illness and I changed my mind and I expressed that to my next of kin. Hence, the next of kin has the authority to prevent that from happening, to actually express that, no, the deceased prior to their passing expressed that they changed their mind and therefore that no longer goes ahead. So that's the first thing. The second thing that needs to happen is the the next of kin needs to actually consent to the organs being donated. So if the family member or the next of kin states that, you know, the deceased had changed their mind and that they no longer consent to the organ donation, the donation will not occur. So that's just quickly on organ donation from a legal standpoint. From an Islamic standpoint, most scholars hold the opinion that organ donation is permissible as long as certain conditions are fulfilled. So the first condition is that, you know, the donor is not harmed by the donation. The second is that the recipient requires the organ in order to live or in order to perform an essential function. So it can't just be for, you know, cosmetic reasons or whatever. It has to be an essential and necessary need. The donor's body, whether living or dead, is respected and treated with dignity. So that's a very critical condition from an Islamic standpoint. The fourth is that the donor gives his or her organs freely. Obviously, they were not forced prior to passing or whatever it is. They were not put under any pressure or duress to actually donate. And the fifth is that the organs are not bought or sold. So this opinion is actually based on, you know, a well-established legal principle from an Islamic standpoint in that necessities overrule prohibitions. So most scholars actually hold the opinion that as long as those conditions are fulfilled, there is no issue with organ donation. Anything else in relation to, you know, matters concerning organ donation, we always like to get clarification on and seek fatwa for. So generally speaking, with all these sorts of things, there's not always going to be a blanket answer, right? We sometimes must and need to actually seek fatwa when it comes to these issues. Moving on, I wanted to also touch on embalming, cremation, and autopsies. So embalming in layman terms is mummification, right? So you know what mummification actually involves? That's exactly what embalming almost is. It is required and critical and essential if the corpse is to be transported for burial purposes anywhere. So say, for example, from one state to another state, or from one country to another country. So from Australia to another country, legally speaking, the corpse must be embalmed. It is an extremely invasive process, extremely invasive. So there is no regard or consideration for the awrah. There is no regard or consideration for, you know, dignity to the deceased. In the same way that the Islamic principles are fulfilled when it comes to ghusl and the washing of the body, embalming poses a completely different scenario here. And all scholars, both classic and contemporary, agree that embalming is prohibited in Islam. It's not something that we can and should ever consider. I know for a fact, and I've had this happen particularly with elderly clients, there is usually this yearning to go back and be buried in the homeland. And I always advise them from an Islamic standpoint, I'm talking about obviously Muslim clients, that in the event you choose to be transported back to the homeland after death, the embalming process must take effect, and this is not Islamic. So we have an obligation to advise, whether it's our elder parents or family members or friends or whatever, who have this yearning. I understand there is this yearning at times to go back and be buried in the homeland, but you know, the prophetic advice is to be buried on the land in which you passed, and that is what we should follow. The second thing is cremation. So cremation involves burning of the deceased, and this procedure has been very common recently, primarily for the you know, the exclusive reason of it being such a cheap option of burial. So burial is quite expensive. It's not cheap. It's quite an expensive process to have to undertake and so forth. Cremation has been a much cheaper option for many. So from an Islamic standpoint, the cremation of the deceased is completely impermissible because it does not provide any benefit for the deceased. And it goes back to the principle of ensuring that we have a duty as the living to respect the dignity of a human being and preserving them from harm even once they have passed. So cremation is also prohibited in Islam. Moving on to autopsies, because that's also a very contentious issue in our dealings generally. So autopsies are the post-mortem examinations that usually take place, and they involve, you know, the dissection of the deceased body. So Islamically, this should be avoided, right? This actually should be avoided. And if it is legally required, you don't have to surrender completely. You actually have ways and means and tools to potentially oppose the autopsy. So first and foremost, the family should actually object to any internal autopsy and request non-invasive diagnostic procedures. So you've got, you know, blood tests, tissue samples, imaging, or radiological examinations, and or CT scans, MRIs, and so forth. So generally speaking, there are ways to object to it, right? You don't have to just completely surrender and accept. The objections have to be made to the relevant state coroner, must be done in writing, and there are specific procedures. And you can usually find this on the coroner's website. Many people are not aware that just because a corpse is deemed to have to legally go through an autopsy, you can actually oppose it. There is a legal method that actually many times is generally accepted. So it's just about actually going through that process. Let me just quickly sift through the questions. Okay, so we've covered a lot of this. We need to, if you die in hospital, how are you to intercept the body before the embalmment? Well, this is why, I mean, again, I will cover this, but generally speaking, this is why it's very important, A, that firstly, obviously, you have a will. Secondly, you've appointed an executor who will ensure that the wishes that you stipulate from the moment you pass to the specifics, right, of your funeral and burial arrangements are actually upheld. You have, it's amazing, subhanAllah, I've got clients that are very, very specific as to the instructions they want to take place from the moment they pass, whether it's hospital, whether it's, you know, at home, wherever it is, they have specific instructions, and they've had a conversation with their executor during their lifetime. So one thing that I'd like to break tonight, I guess, is that stigma around the topic of wills with one another. So when you, for example, prepare a will and you've appointed an executor and you have beneficiaries, it's not meant to be a top secret document that you're, you know, to bury somewhere, you know, somewhere safe or hide underground or anything like that. It's not supposed to be that way. You should have a conversation with your executor and reaffirm the wishes that you've actually stipulated. Make it very clear, because don't forget, this is the only time in your life that you have no control over anything that will happen to you. So you are counting on this person that you appoint to ensure that your wishes and instructions are actually upheld. So have the conversation with your executors and beneficiaries, and don't shy away. There's absolutely no harm, and we need to break that stigma. So what is the rule of, sorry, just missing some of the, okay, I can't sift through all of them, but can we let coroner know our wishes in this now? No, it's done once you pass. So autopsies will only arise once a person passes, potentially. In your will, however, we do stipulate, so in all the wills that we generally draft, we make it very clear that, you know, that the deceased does not wish to be embalmed, cremated, or have any autopsies or invasive procedures, you know, undertaken. That's stipulated in their will. However, it will not become an issue unless the corpse is deemed to have to go through the autopsy process. So you can't sort of just write to the coroner from now and sort of say, hey, just putting it out there that if and when I pass, I oppose or object to the autopsy. No, you would have to wait until and if you have to go through that process. Advise to reverts that haven't told their family they are Muslim as to where the will should go. Absolutely, this is critical. And when people ask me, I don't have anything in my will, if, you know, to leave in a will, why do I need a will? Well, this is one. So particularly if you are a revert, and if the topic of you reverting to Islam is still sensitive, particularly around those that, you know, are close to you, you need to ensure that you have a will in place. And you need to ensure that your family members, whoever they may be and whatever their views are on your reversion to Islam, you need to make it very clear that you have a will in place and that you have an appointed executor, and you wish for your you want your wishes to be actually executed by the executor. It's very important to have that conversation, as uncomfortable as it may be. It's very important that we need to have this conversation. Maybe it's something Melbourne can talk about. Yes, absolutely. Just moving on, and then I'm actually going to see with you, Yeliz, if we wanted to open it up to Q&A, because I know it's 8:40. Very quickly, this is what I wanted to also cover. This concept of, so the common questions that we get asked is, for example, I am a Muslim and I have non-Muslim family or parents, because we know from an Islamic standpoint, parents have a right to inherit, right? They're entitled to 1/6 of your estate. Can I, so if I'm Muslim, my parents are not Muslim, can I leave a share for them in my will? Now, all scholars, or most scholars, actually agree that non-Muslim parents do not have a right in their child's inheritance from the primary prefixed shares, meaning the 1/6 shares. They don't have a right to that. So where you would account for them is from that 1/3, right? So you can actually account for your parents, and the advice is that you should, particularly if you have a good relationship with them, you should leave something for them from the 1/3 wasiyah or bequest. And reason being is because you want to leave something positive, for them when you are no longer here. So you are permitted to make, a will within the 1/3 share of your inheritance to your non-Muslim family members, not just your parents, but even family members. So if you've got siblings, if you've got aunts and so forth, and you prefer that, you'd leave them with something, it's considered a charity and you can actually leave it for them. Now, can I, if I'm a Muslim, can I inherit from my non-Muslim parents? Again, the advice and the majority of scholars agree that yes, you can, as long as, firstly, it is specified in a will. So your parents, deceased parents, have left something for you in their will, and it doesn't exceed 1/3 of their estate either, right? So you have been accounted for from at least no more than 1/3 of their estate. Now, I always make it very clear that if you are in a complex scenario and things aren't straightforward, you should never go with a blanket answer. So for example, if you have a friend and a revert friend who's gone through something and something similar has happened to you, don't go by whatever fatwa she's received or he's received. You need to go and get a fatwa for your particular scenario. That's what a fatwa is. It is a customized ruling for your particular circumstances and scenarios. So it's very important that we understand that sometimes we actually need to ask our scholars and our imams for specific rulings on our particular circumstances. One of the things that, alhamdulillah, I'm very, very privileged and blessed with is the fact that I have direct connections with the Australian National Imams Council and the Grand Mufti himself. So when I am pressed with very complex issues, or if clients have a bit of a complex scenario, at least we are able to reach out and seek counsel and fatwa from them, inshallah. So just to sum up, and then I want to open it up to Q&A. And I know, again, we haven't done the topic justice, but it is critical that we consider having a will. And particularly in today's climate, as you've seen, we all know of someone who's become very ill or has even passed unexpectedly. My advice always is don't leave drafting your will to a time in which you may be vulnerable. Do it at a time where you have health, where you are in a good state of mind. You are not, stressed and about to travel. I've always had those clients. I'm traveling tomorrow. Can I get a will done? I'm going to surgery tomorrow. Can I get a will done? Or they're on their deathbed, literally, where they've only had days to live and they've left their will to the last minute. It's not good. It's not a good thing to leave your will to a time where you may actually be vulnerable. So the advice is think about your will at a time where you are in a good state of mind, right? In good health, so that you can make sure that you're doing, you're making the best decisions for the most important time of your life, where you are not there to make those decisions for yourself. Though it's important to have a will in place, because at the same time as ensuring that your wishes are, executed, you are avoiding unnecessary delays for the family in distributing the estate. You are avoiding potentially legal, complex and expensive legal battles between family members. He said, she said. Don't leave it to speculation. When you have a will, it just makes things a lot easier. And you don't want to, give the opportunity to others to make those decisions for you. You are the most and best suited to make a decision, not just about your estate, but about your body, how you'd like it to be dealt with, and also to go beyond that, how and who you would like your children to be raised with, inshallah. So I'll leave it there. I don't know if you want to facilitate some questions, Yeliz. We've got about 15 minutes.
There's so many.
I think I've covered some.
You have covered pretty much.
Can I ask you to run over one thing quickly, and I'll unmute everyone as well. So what we'll get you to do, if you just want to ask a question, put your hand up, so we don't have to unmute everyone. We'll just unmute you as we do your hand. But I just realized there's a lot of reverts here that don't actually probably know anything about the Muslim burial process. They probably don't even know we don't get buried in a coffin. Do you know what I mean? Would you be able to just quickly run through that?
So the best person, and I think you should really consider bringing her on board, Sarah, is Sister Mariam Ardati. So she's actually a death doula. I'll send you her contact.
Yes.
She is the go-to person. She actually washes, the deceased sisters. She's in Sydney, very good friend of mine. And she does a lot of death and dying courses, more so about the pre-burial and burial process. But in summary, yes, you're absolutely right. In Islam, we don't, we are not buried in a coffin. We are not buried in our, standard clothing. There is a strict, and it's actually a beautiful attribute in preserving the sanctity, the dignity of the deceased in every way possible, even during the washing process. So generally speaking, the deceased is washed through the ritual process called ghusl, which is the final, I guess, almost, washing that obviously the deceased will get. And they're then subsequently shrouded with, plain cotton, and in which they are later then simply lowered into the grave and the soil. There is absolutely no coffin. So the process, and if you've ever, and look, Sister Mariam, the way that she delivers all her topics and talks, it makes you, it's a bit scary, but subhanallah, it's something that you would not actually be afraid of. She makes the process so beautiful, and quite you adapt to it, and you connect to it in a way that you wouldn't imagine. So Islam has a huge emphasis on preserving one's aura, and especially during the washing process. So because you obviously have no control over who can see you, how your body's dealt with, the rules that are in place gives us this reassurance that we are going to be dealt with in a way that, at least, especially for sisters who have worn hijab their entire life and that have preserved their aura, they will also be looked after once they pass away, once they don't have control over, who deals with them as well.
There is a question at the bottom there. Can you see those?
So an executor ensures the deceased wishes are carried out. If there is a written will that stipulates these things, does the executor go to the lawyer to ensure that it's carried out? Excellent. So, and who can we go in order to have our Islamic will written? So the first question, this is a very important question, because what most people think is once you've done the will, so I, for example, I've drafted my will, I pass away shortly after. That's not the end process. That's just the beginning of the process. the executor has the responsibility to either themselves go through this process or go to a lawyer, which is always a lot easier because obviously the lawyer will do the undertake the process in a much time efficient manner and cost efficient manner. Go through what we call a grant of probate, right? So what a grant of probate is that the executor will present that will to the court, and it's usually something that's filed in the Supreme Court. The judge, if everything's in order, there's a will that's deemed valid, there's nobody that's challenged it, everything seems quite sufficient. The judge literally stamps the grant of probate, and that is then an authority for the executor to go and fulfill the wishes of the deceased. So whether it's sell property, whether it's release funds from banks, release any shares and sell shares, whatever it is, the executor now has full autonomy to do and authority to do that as deemed by the court. So that's a very important question, because I've had clients that had, for example, their parents have a will, their parents passed away, their parents have left things for them in that will, and it's been 10 years and nothing's been done by the children. They've assumed that automatically by their parents writing the will, that's it, everything's theirs. They've completely overlooked that important and critical process called grant of probate. Now, a grant of probate generally needs to be sought within 12 months of the deceased passing. Any time after that, generally speaking, you would need special, permission, additional affidavits and so forth to ensure that, it's going to be approved. It's just a lengthier process. So 10 years after poses a very, very complex scenario for not only the beneficiaries, but even for the executor to have to go through that process. The second question is, where can we go to have our Islamic wills written? We are, alhamdulillah, blessed with many Muslim lawyers. Look, not all Muslim lawyers are well versed in this area. This is my speciality, so it's something that I obviously, provide a service for. But most and many Muslim lawyers have capacity to draft Islamic wills, and I think we need to really utilize the opportunity.
Sis, there is another question.
You're right, yeah, Sarah. Sorry. Just
Yeah.
about the way the body will be used as fertilizing the earth. That's absolutely right. We're created by the earth and we return to the earth in the same manner, subhanAllah.
Someone's got a question. If you don't have a will and you don't have a Muslim family, what do you do then?
I know that's a very difficult situation. Look, you can appoint some lawyers as executors, as and even appoint, have public trustee pretty much appointed. It's a very difficult process. I personally do not, offer to become anyone's executor. It's a very, I wouldn't be able to keep up. You'll need to just have a conversation with your lawyer and get some advice on that issue, but they're generally going to be your two main options. Trusted friends, if there is anyone that you could potentially appoint. If you have children over the age of 18, then that's also an option for you.
What about, worst case scenario, if it was something like your local mosque or Board of Imams or, Melbourne Muslimahs or something like this, just for the worst case scenario. As you said, it's a very time consuming. It's something that can't be done lightly. But, obviously if it's very bad, there's no family at all and they're not speaking to any family. We've seen only a year ago, I think one girl, her family hated that the girl was Muslim. They didn't like that she was Muslim. So the mum took it all to court. It took at least a month for the body to get released to her and got cremated. But the father was fighting for her to get the Islamic burial. It was very nasty. So these things are very real. And I just, yeah, you know what I mean?
Yeah. So, but in the scheme of things, with that particular scenario, and we've been asked, I've had people contact me a day after or the day of, person passing, a revert passing, and asking me, what do we do? And I tell them, you have this option and that option in terms of going to court and challenging it and so forth. But when we talk about the fiqh of priorities, right? On a scale of priorities, what's our priority? It's to get the deceased
body in the ground, yeah.
In the ground, right? Now, if from a legal standpoint they are going to be cremated and you've done everything you can to stop that, that's a good thing. But to extend and delay it for a whole month, Allahu A'lam, but you know, that's also, that doesn't give the deceased justice. So look, there's no one size fits all for that. Now, going back to your question, and that's what I raised right at the beginning, I have been in conversation with the Australian National Imams Council about this issue, in that we need to start thinking about, you know, again, we've got many migrant communities, we've got revert Muslims who have absolutely nobody, and they do need to tap into potentially, if you want to even call it a service, from trusted individuals, at least in our community. Now, generally speaking, we can't appoint a organization. It has to be an individual, generally speaking. I've not seen an organization appointed, and it can be something that can eventually be proposed. But why not within those organizations, if it's publicized, I guess, to the broader community, just in the same way that those organizations have appointed board members that the community trusts? Why can't we also think about appointing trusted individuals within those organizations as the go-to, right?
What about, so sort of like the wali, like when we've got to find a wali for a girl, a revert? So sort of like this, Timmy, like sort of we can sort of incorporate those two, you know, it could be her wali, the same person. Yeah, okay, all right, leave it with us.
Something similar, but they have to be endorsed and trusted and credible, because ultimately, look, from a legal standpoint, they have a huge responsibility. There are jail terms if an executor does not fulfill their responsibilities, or if they are found to abuse their position. But even Islamically speaking, you know, the executor carries a heavy responsibility, and this is an amana. So there's no two ways or a joke. It's not a joke. So if people are entrusting organizations to select individuals, and again, these are just ideas. They're not obviously concrete, but, you know, they have to be very trusted and credible.
Another question, do we have anything like inheritance tax? And if there is there a threshold, or do we have that?
No, there's no death duty. Death duty was abolished a while back. And I can't go into it now, but like I said, this is why this topic requires about 3 to 4 hours. But when it comes to assets, you know, distribution and or sales or transfer, this is where you get done slightly on potential taxes, whether it's stamp duty and so forth. But death duty has been abolished, so there is no death duty. But there are other implications. Look, you know, you're not going to be left untouched. The government will find ways to tax you. So there may be capital gains implications. Outstanding ATO debts are also something that need to be considered. Stamp duty implications if you are transferring property to a beneficiary. So there are other side or collateral issues that will definitely arise, but there is no specific death duty.
Okay, we have another question. In case of a woman remarrying with a shared account with the new spouse, how do we include children from the first marriage?
Sorry, can you repeat? Can you repeat
the last question? So in case of
in case of a woman remarrying with a shared account with new spouse, how do we include children from the first marriage, please? Well, you need to be very careful. It's taken, I guess, this is general, so we'll need to really nut it out. But generally speaking, if it is a joint account, you would be treated to own 50% of that account, and your spouse owns 50% of that account as well. And then your spouse is only entitled to his portion, Islamic portion, from your 50%. So for example, he is entitled to a quarter of your 50%, and you are entitled to an eighth of his 50%. And his children from the first marriage have an absolute right to their share from his 50%. But that needs to be clearly stipulated in the will, because it's very important that, you know, that separation is there. Otherwise, someone's rights may be overlooked in some way or another. Nonetheless, these are his biological children or your biological children. I've had scenarios where, yes, it is a second marriage or remarriage, for example, and there are biological children from, you know, previous marriages, and the spouse has, you know, imposed on the wife, for example, or vice versa, that they don't want the children to inherit from the biological parent. This is Islamically, you know, is inaccurate, and it's not something that we actually are permitted to do. Every biological child has the right to inherit from their biological parent. So you cannot expect that that right be waived or forfeited just because of remarriage.
Oh, Sister Ramia, thank you so much for joining us. I know you've got a busy night ahead, so
yeah, I think we'll wrap
that's
it
right.
up now.
I'll take one more question. When you write a will, who do you give the will to? Sorry, I'll answer that. That's a very important one. So generally speaking, you sign the original will. If you come, for example, to the lawyers, what we normally do is, we get you to sign the original will. Most lawyers hold on to the original will so that in the event you pass, at least the executors come back to you and go through the grant of probate process. I personally like to give the client back their original will so that, they're not restricted as to where they go. I always advise you, as in the person writing the will, to give the executor a copy of the will. Always give the executor a copy at least. It's very important that they at least know that you do have a will in place, that, they have a responsibility on their hands and so forth. Don't leave it to surprise, basically. So it's very important to, if you don't want to give your lawyer, obviously, a copy of the original will, at least give the executor a copy of the will. And look, start having these conversations even with your beneficiaries. There's no harm in telling your beneficiaries, your children, hey, look, it's an Islamic obligation. It's not something to shy away from or hide. Nobody's going to, normal circumstances, nobody's going to intentionally come and try to kill you, I guess, just to, unless there's, extraordinary circumstances. It's quite unusual. But we need to put these things and ideas aside and really start thinking about being transparent during your lifetime to ensure that a smooth process is facilitated once you pass away, inshallah.
Yeah.
If anyone has any questions, sorry, what I'm going to do is I'm actually going to share my contact details in the chat. If that helps, I'm happy to do that. Feel free to, because I know I can't cover all questions, feel free to email, call, whatever it is. And I'm happy to answer any pressing questions, inshallah.
Okay, yeah, such an important topic, isn't it? Like, we make all these decisions on, before we get married and, when we're going to buy a house, but this is like our ticket to Jannah. Like, this is like, our last will on this, on this earth before we face Allah subhanahu wa ta'ala. So
it's the most important document you would actually write during your lifetime. I can't put it in any other terms. It's going to be the only document that you would actually, be able to write and hope that it will get affected once you pass away. So it's very important that we consider it and, think about it at a time, as I said, when we are not vulnerable, when we are well and able to think straight about these important issues that arise.
Yeah. So we'll just wrap it up, inshallah. So on behalf of Melbourne Muslimahs, we just like to thank you for joining us tonight and making the time for being here and discussing this important topic. It was I found it very informative and very insightful. I've taken in so much information from your knowledge and wisdom, so thank you. It was an absolute pleasure, inshallah.